Hello and welcome. I am Dr. Manvendra Kumar Tiwari, Associate Professor, Dharmshastra National Law University, Jabalpur. I welcome all of you to our legal reasoning discourse on the preparations for the common law admission test. Today, in continuation of what we were discussing earlier, we will discuss the right to personal liberty under Article 21 in the legal reasoning part. We have seen that right to life and personal liberty forms part of Article 21 of the Constitution of. And in my earlier uh, videos, I have discussed due process and right to life in particular. Today, I will be discussing the third and final aspect of the right to life and personal liberty, that is personal liberty. I have broken Article 21 into three. One, where I discussed the due process and the procedure established by law distinction. Second, where I discussed the meaning of right to life, to tell you as to how right to life uh, means, first of all, not only negative rights, but also positive rights, and how the courts have liberally interpreted right to life to mean access to basic human needs. Today, we will discuss right to personal liberty. However, before I start discussing right to personal liberty, I want to flag this important disclaimer that though I am discussing right to life and right to personal liberty separately, but right to life and personal liberty is not read disjunctively or in a mutually exclusive manner. It is always read together. And there is a purpose behind the reading of the two, right to life and right to personal liberty, together, because one derives its meaning and extent from the other. So when I'm talking about right to personal liberty, it is not as if the meaning of right to life has got nothing to do with right to personal liberty. And likewise, if something that flows from right to personal liberty, the same will also add to the extent of the understanding of right to life. And therefore, it should not be understood that right to life is only limited to what we discussed in our earlier lecture, and right to personal liberty is exclusively confined to what we will be discussing today. So, personal liberty is very much associated with right to human dignity. Dignity is something which we saw in our last recording, that right to life means right to dignified life according to the Supreme Court of India. But this dignified life would also demand right to personal liberty. That is what I meant when I said that right to life and right to personal liberty should not be read in a mutually exclusive manner. I am doing it just to break it and just to tell you that perhaps things that we will be that the things that we will be discussing today are more uh, proximate to personal liberty aspect of Article 21, but that is not to say that it is exclusively confined to the personal liberty aspect of Article 21. It is very much deriving its meaning from right to life as well. So we'll move ahead with this disclaimer uh, and discuss right to personal liberty. I will discuss right to personal liberty with the help of a few passages, and then we'll also solve a few questions based on those passages. And simultaneously, while reading the passages, we'll also try to understand how the passage is actually emphasizing upon the aspect of personal liberty. So, moving ahead, this we have seen Article 21 of the Constitution reads that no person shall be deprived of his life or personal liberty except according to the procedure established by law. This is the literal version of Article 21. We have already seen what is the contemporary understanding of the term procedure established by law, and we have also seen how life is to be read as a dignified life, and what dignified life would therefore demand. Today, we'll exclusively be focusing on the personal liberty aspect of this right. However, with this realization that personal liberty aspect is also very much influenced by the right to life aspect, 21. Now, this is a passage from an article that was recently published both in Indian Express and in Bar and Bench. I have taken it from Bar and Bench, which is a legal news portal. And this is about some of the judgments of the Supreme Court delivered primarily in the year 2024 in matters related to bail. So we'll see as to what bail means. It's given in the passage itself. So the passage reads, successive recent judgments of the Supreme Court of India have reaffirmed its commitment to constitutionalism and given meaning to the words of Sri Chimanlal Shah, who during the Constituent Assembly debates said that the right to life and personal liberty is the most fundamental of the fundamental rights. So it is emphasizing Mr. Chimanlal Shah from Constituent Assembly, one of the framers of our constitution, is saying in the Constituent Assembly that among the fundamental rights, the right to life and personal liberty is most fundamental. That tells you even among the fundamental rights, the right to life and personal liberty is the most significant and important right. So it reads, the right to life and personal liberty is the most fundamental of the fundamental rights, without which all other rights are meaningless. Taking note that often criminal trials become a judicial quagmire where the process becomes the punishment. An important observation. In criminal trials, the process becomes the punishment. We'll see as to what this phrase means. The Supreme Court has held that a constitutional court cannot be restrained from granting bail to an accused on account of restrictive statutory provisions in a penal statute. It finds that the right of the accused under trial under Article 21 of the Constitution of India has been infringed. A regular bail, this is actually an explainer, a regular bail is the order of the court to release an arrested person under trial pending the conclusion of trial. And trial is the process in the lower criminal courts to determine whether or not the accused person is guilty. So this passage is highlighting how the Supreme Court in the recent past, while granting bail, and what bail is that an arrested person, while the case is still to be decided, wants that he or she should be freed pending the conclusion of trial, and that he or she should only be imprisoned if there is a punishment of imprisonment imposed upon the person pursuant to the conclusion of trial, where in the trial he or she has been held guilty. So the process of bail ensures fairness in the sense that if a person whose trial is ongoing remains in jail and pursuant to the conclusion of trial, if the person has been granted bail, if the person has been acquitted, then the fact that the person remained in jail for the period while the trial was ongoing is unjust and unreasonable. And that is why, to the extent possible, the person must be given bail, that the person must be freed pending the conclusion of trial, so that this injustice in the event of the final order in the case being an order of acquittal in favor of that person, there is no case for injustice for the person being imprisoned without fault. And however, the problem is that bail, if you give bail to somebody who does not deserve to be freed, then probably that person is a threat to the society. That person is even a threat to the witnesses who may depose before him in the trial and ensure that he is convicted. So therefore, and also a person who is on bail may actually escape and never face trial. So these are some of the problems which weigh upon a court in denying bail to an arrested person. But what the Supreme Court is highlighting, that the Supreme Court is highlighting the importance of personal liberty under Article 21 of the Constitution of India. And the Supreme Court is saying that a constitutional court cannot be restrained from granting bail to an accused on account of restrictive statutory provisions in a penal statute. Penal statute is talking about criminal statute. Restrictive statutory provisions means there are some special criminal laws or penal laws which give a very restrictive scope for granting bail. So, if a person is charged under those legislations, the likelihood of being released on bail is diminished compared to ordinary cases of crime. And that is what the court is highlighting, that even when it comes to the restrictive statutory provisions in a penal statute, if the Constitutional Court finds that the right of the accused under trial under Article 21 of the Constitution has been infringed, then the court can go ahead and grant bail. Reading further, scholars, civil society activists, legal practitioners, and all others who hold dear our constitutional values are comforted by the recent verdicts and yearn that the diktat from the Supreme Court trickles down the judicial ladder and also sticks with the law enforcement agencies. Following our constitutional jurisprudence, Supreme Court most recently in Jalaluddin Khan versus Union of India observed that the lower court and the high court did not consider the material in the charge sheet objectively and was swayed by accusations that the accused belonged to an unlawful organization and was charged under the Unlawful Activities Prevention Act 1967, which is a special law which provides less room for an arrested person to be released on bail. Notwithstanding, it ruled that if the court starts denying bail in deserving cases, it will be a flagrant violation of Article. Similarly, in the case of Manish Sisodia, Manish Sisodia, former Deputy Chief Minister of Delhi, in the case of Manish Sisodia versus Directorate of Enforcement, court noted that trial and high courts in matters of bail attempt to play safe, and the principle that bail is a rule and refusal is an exception is at times followed in breach. Like in Sisodia's case, who had been in jail for 17 months, in Sheikh Javed Iqbal versus State of Uttar Pradesh, the accused was detained by the anti-terror squad since 2015 and was also charged under UAPA. The Supreme Court held that every accused has a right to a speedy trial, and bail cannot be denied solely on the ground that the offences are serious in nature. Relying on its previous judgments, the court emphasized that the period of custody undergone and the likely time in which the trial will be concluded must be borne in mind when freedom is at stake. Along similar lines, in Arvind Kejriwal, the former Chief Minister of Delhi, Arvind Kejriwal versus Directorate of Enforcement, the court, while referring the question of whether need and necessity of arrest is a separate ground to challenge the arrest under the Prevention of Money Laundering Act, referred the question to a larger bench. So in this case, the Kejriwal had challenged that there was no need and necessity of arrest. So the question before the court was whether an arrested person can even challenge arrest on the ground that there was no need and necessity of arrest, and whether the court can actually examine independently this question, whether there was a need and necessity of arrest. What happens under the criminal laws, the procedural criminal law in India, every offense is designated as either cognizable or non-cognizable. In cognizable offenses, the police gets the right to arrest the person without a warrant from the court. Now, having the right to arrest and having the need to arrest are two separate questions. And therefore, Kejriwal's lawyers have argued that the right to arrest would not simply suffice. The right can only be exercised if there is a need and necessity of arrest, which is there in the Money Laundering Act. And the ED must prove that there was a need and necessity of arrest, and the court can actually scrutinize the correctness of this argument. Court did not answer this question, and the Supreme Court referred this question to a larger bench for the larger bench to decide the matter in future. Court, however, observed that the power of arrest is not unbridled, and the necessity to make an arrest should be considered by police before making an arrest. Rather than deciding the question, it said the police nevertheless must consider if there is necessity to make an arrest. There is enduring public support for courts and wide acceptance of their authority. Considered in the background, these recent pronouncements highlight the paramountcy of individual freedom and the need for all courts in the judicial hierarchy to recognize this and apply it to the cases before them. A clear message has been delivered that all courts exercising discretion must do so judicially and not be swayed either by the parties involved or charges leveled. After long, the court is speaking in unison, and the voice of liberty is ringing loud through the hallowed corridors of Supreme Court, where unjust impingement of citizen rights is finding no place. Nothing must eclipse this, because personal liberty must triumph under all socio-political conditions. So this is the passage from 4th September 2004, Bar and Bench, an article, this excerpt which has been edited, and the article from where this excerpt has been taken was written by a senior advocate of the Supreme Court, Mr. Sathvik Verma. Coming to a few questions based on this passage, Shri Chimanlal Shah, who during the Constituent Assembly debate said that the right to life and personal liberty is most fundamental of the fundamental rights. We saw that, so option B is the right answer. Scholars, civil society, activists, legal practitioners yearn that the diktat from the Supreme Court trickles down the judicial ladder. So option C is the right answer. In the case of Manish Sisodia versus Directorate of Enforcement, the Supreme Court noted that the trial and high courts in the matters of bail attempt to play safe, and principle that bail is a rule and refusal is an exception is at times not observed. It is observed in breach is what the passage says. So not observed is the correct answer. Option A is the correct answer. The Supreme Court concluded that when freedom is at stake on a question of bail, the period of custody undergone must be borne in mind. Yes. The likely time within which the trial must be concluded must be borne in mind. Yes. Option C, both A and B. So option C is the right answer. In Arvind Kejriwal versus Directorate of Enforcement, the Supreme Court referred the question of whether need and necessity of arrest is a separate ground to challenge the arrest under the Prevention of Money Laundering Act to a larger bench. We saw that, larger bench of the Supreme Court. That means option A is the right answer. Sixth question. Personal liberty must triumph under all socio-political conditions. This is the last sentence of the passage. Now moving ahead, right to privacy. Right to personal liberty and right to life, a collective reading of right to life, which gives rise to a right to dignified life, and right to personal liberty, has actually been read so as to give rise to a right to privacy under Article 21 of the Constitution of India by the Supreme Court of India on 24th August 2017. A 9-judge bench of the Supreme Court in K.S. Puttaswamy versus Union of India unanimously recognized a fundamental right to privacy of every individual guaranteed by the Constitution within Article 21. The decision in MP Sharma and Khadak Singh cases were overruled. What is important is that this is a judgment by a 9-judge bench, a unanimous verdict with no dissents, delivered only on 24th August 2017, which recognized right to privacy as a fundamental right and overruled two judgments of the Supreme Court in MP Sharma and Khadak Singh, which had stated that right to privacy is not a fundamental right. So even though some of the things may appear very elementary, some may be very obvious, but it tells you that that may not actually be the case. 67 years for the courts in India from the commencement of the Constitution to actually recognize right to privacy as part of Article 21. So, what is right to privacy? Right to privacy is the right to privacy recognizes the ability of individual to control vital aspects of their life and safeguard the autonomy exercised by them in decisions of personal intimacies, matters of home and marriage, the sanctity of family life and sexual orientation, and all of which are at the core of privacy. So that's a very wide definition, which uses terms which are very expansive words like autonomy, uh, ability of an individual to control vital aspects of their life. These are the terms which are self-capable of interpretation, and that's why I said that the import of right to privacy is wide. Moving ahead, right to privacy, like it is mentioned, even sexual orientation is something which forms the core of the right to privacy. And this judgment came before the Supreme Court had delivered its judgment in Navtej Singh Johar versus Union of India, which read down Section 377 of the Indian Penal Code to the extent it made acts against the order of nature and homosexuality and the sexual expression of LGBTQ community as an offense. The Supreme Court read it down and declared it to be unconstitutional. And the judgment of Puttaswamy, which recognized sexual orientation as something which is part of Article 21 under right to privacy, had in a way already ordained the fate of Section 377 of the Indian Penal Code. And the eventual fate was actually realized in this Navtej Singh Johar versus Union of India judgment. A 5-judge constitution bench of the Supreme Court finally struck down the colonial era law criminalizing homosexuality in the lives of LGBTQ persons. In a 493-page verdict with 4 concurring judgments. Concurring judgments are judgments where each of the judge on the bench would write their own judgment. However, the judgments, so far as the decision is concerned, agree, yet the reasons may be different or additional from the other judgments, and that's why judges write concurring judgments as well. So, in a 493-page verdict with 4 concurring judgments, 5 judges were there. That means only one judge did not write the judgment, and he signed on the judgment of some of the other brother judge. Court traversed the protections of fundamental rights in the Constitution, find that the provision violated the rights of LGBTQ persons to dignity, equality, privacy, and expression. As you can see, privacy is also something which is violated by a provision like Section 377 Indian Penal Code, because it is making sexual orientation an offense. It is making a personal intimacy an offense. So clearly, this is violative of privacy. But apart from that, the court also found this to be violative of person's dignity, going from Article 21 in particular, the right to life, which means right to a dignified life, equality under Article 14, because this is discriminatory treatment based on sexual orientation. And that's why this is equally violative of equality and expression, because right to freedom of speech and expression, obviously, if something is a crime, no one has the right to espouse it. Therefore, a legitimate freedom of expression is being suppressed because of this criminalization of a legitimate conduct by the criminal law. So, as you can see that the law was declared unconstitutional on account of various fundamental rights flowing from Article 21.14 and Article 19. Moving ahead, personal matter. The court said that what Section 377 is actually trying to criminalize falls within the personal matter of individuals. The judges were unequivocal that Section 377 of the Indian Penal Code cavalierly intruded into a zone of intimate decision, which is entitled to a constitutional protection. As Justice D.Y. Chandrachud put it, the choice of a partner, the desire for personal intimacy, and the yearning to find love and fulfillment in human relationships have a universal appeal. And the state has no business to intrude into these personal matters. Nor can societal notions of heteronormativity. Society expects everyone to be in a heteronormative union. So only a male and a female should have any sexual union. Nor can societal notions of heteronormativity regulate constitutional liberties based on sexual orientation. The opinion of the Chief Justice of India, the then Chief Justice, Mr. Deepak Mishra, invoked Johann Wolfgang von Goethe, Arthur Schopenhauer, and John Stuart Mill to stress the right to develop one's individuality against the demands of social conformity. In the context of LGBTQ persons, where struggle is often to assert one's personhood in an isolating, ostracizing environment in which heterosexuality is the norm, the constitutional protection given to intimate choices against the diktats of social conformity cannot be overstated. This is a very important observation. It is stating that just because in the society heterosexuality is the norm, that does not mean homosexuality therefore becomes an offense. So this social conformity cannot be demanded by criminal law if the conduct in question is an innate human quality. And that is why this is an important observation. But this observation also in a way highlights the challenge, because the Navtej Singh Johar judgment has decriminalized homosexuality and the criminalization of LGBTQ community in particular. But the societal attitude towards homosexuality and the LGBTQ community has not undergone change just because the Supreme Court has delivered this judgment. There still is a wide gulf between what can be called the constitutional morality flowing from the constitutional provision and its reading by the courts and the popular social morality. Okay, so therefore, this may be a judgment which has made it impossible for the state to actually prosecute people and punish them. At the same time, the judgment in itself will not alter the social morality. It will take the consistent practices of reiterating constitutionally moral conducts for the constitutional morality in this case to actually prevail over the popular social morality, which treats heterosexuality the norm. And that is also one lesson that one must learn from this observation. The logic of Navtej Singh Johar is anchored within what both Justices Mishra and Chandrachud called a transformative constitution. Transformative constitution is a constitution which sees the future, and by doing so, it provides for provisions which are actually transformational in character. Therefore, it is not just one instance which is agitated before the court that the constitutional provisions are actually limited to. The constitutional provisions recognize that there is a gulf between the popular social morals and the constitutional ideals. And therefore, in that sense, it wants to alter those popular social morals in conformity with the constitutional ideals. And therefore, in that sense, the Constitution therefore transforms. According to Justice Mishra, the purpose of having a constitution is to transform society to embrace therein the ideals of justice, liberty, equality, and fraternity. The mandate to transform society in allegiance to the Constitution is vested in the state, judiciary, and the citizen. So this is an excerpt which is taken and edited from the Hindu, 10 September 2018. I will see a few questions based on this. In Navtej Singh Johar versus Union of India, the court traversed the protections of fundamental rights in the Constitution to find that the provision violated the rights of LGBTQ persons to dignity and equality, privacy and expression. All of the above. We clearly saw that. So option D is the right answer. According to Supreme Court, the societal notions of heteronormativity regulate constitutional liberties based on sexual orientation, and it cannot intrude into personal matters. So option A is the right answer. The right to develop one's individuality against the demands of social conformity was endorsed by Justice Deepak Mishra. We saw that. Moving on to the third passage, and this is based on judgment of the Supreme Court in Joseph Shine versus Union of India, where the Supreme Court declared Section 497 of the Indian Penal Code to be unconstitutional on two counts. One, because it criminalized adultery, and second, because it made adultery an offense only at the behest of the husband in a marriage. So this was clearly discriminatory. Why should the right to prosecute one's spouse be only limited to husbands and not wife? Does that mean that the husband is permitted to be in an adulterous relationship? So, and the wife will not be in a position to prosecute the husband. Whereas if the wife would commit the act of adultery, the husband is in a position to prosecute. It was clearly arbitrary. Therefore, also struck down on this count. Okay. Now moving ahead. Now, like was the case in Navtej Singh Johar, the Supreme Court in this case also said that sexual relationship is a matter of choice. Two individuals may part if one cheats, but to attach criminality to infidelity is going too far. Two individuals who are in a marriage may part if one cheats. To attach criminality to infidelity is going too far. Means the court is saying that the act should not be an offense. The act of adultery should not be an offense. Why? Because the act of adultery is a matrimonial wrong against the marriage, and adultery is therefore already a ground of divorce in the family laws. So a person who is aggrieved in a marriage has got the right to take divorce on that ground. The court is saying that person has got no right to actually prosecute the person, and because adultery is a crime. Adultery should not be a crime, is what it's saying. Two individuals may part if one cheats, but to attach criminality to infidelity is going too far. The Chief Justice observed, besides, there is no data to back claims that abolition of adultery as a crime would result in chaos in sexual morality or an increase of divorce. How married couples deal with adultery is absolutely a matter of privacy at its pinnacle, the Chief Justice wrote. So here again, the privacy has made inroads. So even if a couple decides to take divorce from the spouse, one of the spouses in a marriage decides to take divorce, the court is saying this is also something which is personal, even if it is based on adultery. It's covered by the right to privacy. Chief Justice wrote, loss of moral commitment in a marriage creates a dent in the relationship, but it is left to each individual to deal with the problem. Some may forgive while others may seek divorce. Punishing each other or the wife's lover, as is the case with Section 497, which was also problematic because of this reason also. Punishing each other or the wife's lover is unlikely to rekindle commitment, judgment said. Adultery is not a crime if the cuckolded husband connives or consents to his ex-wife's extramarital affair. That was the case with Section 497. Section 497 therefore treats a married woman as the husband's chattel, which means loss of moral commitment in a marriage creates a dent in the relationship. Oh yeah, that we read. The provision is a reflection of the social dominance of men prevalent 150 years ago, the judgment said. So this is again something which is a relic of the past so far as the morality codified in Section 497 of the Indian Penal Code is concerned. Section 497 is archaic and based on chauvinistic reason that the third party male has seduced the woman and she is the victim. Justice Nariman took the case of a woman who is on the verge of getting a decree of divorce. If she has sex with another man, Section 497 still makes the other man guilty of adultery. Husband is not the master. Obituaries should be written of these historical perceptions, Chief Justice Deepak Mishra observed. Now we'll see a few questions based on this passage. To attach criminality to infidelity is going too far, clearly directly taken from passage. Adultery is not a crime if the cuckolded husband connives or consents to his wife's extramarital affair. Section 497 treats a married woman as her husband's chattel property, both A and B. So option C is the right answer. A couple punishing each other for adultery is unlikely to rekindle commitment. Is likely to rekindle commitment. Is unlikely to rekindle what the court did. And that is why it should be a matrimonial wrong, as is the case, and that should be a ground for divorce, and it should not be a crime. So that is it so far as the right to personal liberty is concerned. See you soon in our next lecture.